Welcome, curious minds, to another deep dive. Today, we're peeling back the layers on something that sounds a bit like a secret government document, maybe, but is actually crucial for anyone navigating the world of taxes. Okay, let's unpack this. We're talking about Circular 230. It's not a secret spy code, though, the name might make you think of one. Instead, it is the comprehensive rulebook that governs who can represent you before the IRS and exactly how they must conduct themselves. Think of it as like the ultimate guide to ensuring integrity and competence in tax practice for those who advise you. It's a framework designed to build and maintain trust in a really critical relationship.
That's exactly right. And what's truly fascinating here is that Circular 230 is precisely what underpins the trust and professionalism between you, your tax advisor, and the Internal Revenue Service. It's officially titled Regulations Governing Practice before the Internal Revenue Service, and it provides a very clear, detailed, and robust framework for ethical conduct, diligence, and accountability for tax professionals. Without these rules, the entire system and the confidence taxpayers place in it would frankly be incredibly vulnerable, sort of the invisible shield protecting countless transactions.
Okay, so our mission today is to cut through the jargon, illuminate some of the surprising specifics, maybe, and give you a shortcut to understanding the critical responsibilities your tax professional adheres to. You'll walk away knowing exactly what good practice looks like and why these rules are so vital for protecting you, the taxpayer, from potential misconduct or negligence. We want you to feel empowered by this knowledge, to understand the safeguards in place for your financial well being. So, before we dive into the nitty gritty of individual rules, let's get a clear foundational picture. What exactly is the Circular 230 document and what are its main components? Where does it even come from?
Sure. At its core, Circular 230 is an official IRS publication. It's essentially the Internal Revenue Service's own code of conduct, specifically tailored for anyone who practices before it. It's incredibly comprehensive, outlining everything from the very basic qualification of who is even allowed to speak on your behalf to what happens if those rules are broken. We can think of it as a multi-part guide. First, it sets out the rules governing the authority to practice before the IRS, essentially, who gets to do it and what credentials they need. Second, it details the crucial duties and restrictions that relate to this practice, defining the ethical and professional standards practitioners must uphold in their day-to-day work.
Okay.
Third, it specifies the sanctions that can be imposed for violations of these regulations, making it clear what the consequences are for noncompliance. And finally, it lays out the rules applicable to disciplinary proceedings themselves, ensuring a fair process if a violation is alleged, kind of mirroring due process protections you'd expect elsewhere in the legal system.
Right, due process.
And to give you a sense of its structured approach, the publication is actually divided into 5 distinct subparts. There's Subpart A, covering the rules governing authority to practice, which defines who can practice. Subpart B, which is quite extensive and we'll probably spend a lot of time on today, focuses on the duties and restrictions in practice before the IRS.
That sounds like the meat of it.
It really is. Then we have Subpart C, dealing with sanctions for violating the regulations, and Subpart D, outlining the rules applicable to disciplinary proceedings. Finally, Subpart E covers general provisions, which includes things like definitions and effective dates. This structured approach isn't just for organization, it's designed to provide clarity and predictability for practitioners, letting them know exactly where to find the rules relevant to their conduct.
Okay, so this isn't just bureaucratic red tape. It's the very foundation for ensuring that the people helping you with your taxes are held to incredibly high standards. It's about ensuring competence, honesty, and, well, a level playing field for everyone involved. For you, the taxpayer, it's a vital layer of protection designed to safeguard your personal financial well-being and maintain confidence in the integrity of our, let's face it, complex tax system. It makes perfect sense that there's a strict rule book for such an important area of professional service. Okay, so we've established it's a big deal. But here's where it gets really interesting. Who exactly falls under the umbrella of a practitioner governed by Circular 230? Because it's not just any individual who helps prepare a tax return, is it?
No, that's a crucial distinction and honestly a common misconception. Circular 230 specifically applies to a defined group of professionals who are authorized to represent taxpayers before the IRS. These are individuals who have met certain educational, examination, or experience requirements and maintain their credentials. It signifies a certain level of expertise and accountability. The primary categories explicitly listed in Subpart A, Section 2 are attorneys,
Okay.
certified public accountants, or CPAs,
Right.
enrolled agents,
Uh-huh.
enrolled actuaries, and enrolled retirement plan agents. There's also a category for registered tax return preparers, though the scope of their representation is generally more limited. Each of these professions brings a specific set of skills and qualifications to the table, but critically, all are bound by Circular 230 when dealing with the IRS on your behalf.
Got it.
And it's also worth noting that Circular 230 makes an allowance for other persons to represent a taxpayer, but only in very limited and specific circumstances. It's almost like a narrow exception to the general rule. For example, an officer or a full-time employee of a corporation or trust may represent that specific corporation or trust before the IRS.
Ah,
Right.
okay. So like internally.
Exactly. This isn't a general authorization to practice for the public, but rather an allowance for internal representation that doesn't require the formal credentials of the other listed practitioners. It's designed to allow, say, a company's CFO to represent their own company in an IRS matter without necessarily needing to hire outside counsel for every minor issue. It highlights the precise nature of these regulations.
So if you've ever entrusted your financial well-being to one of these professionals for an IRS matter, whether it's an audit, an appeal, or just preparing your annual return, this deep dive is directly about the rules that protect you and guide their actions. It truly shows the immense level of trust and responsibility placed upon them, and why understanding these regulations is so valuable for you as a client. Let's really get into the nuts and bolts now. First up, what are the absolute essentials? What must practitioners do when it comes to information, accuracy, and truthfulness in their dealings with the IRS and, by extension, with you, their client?
Absolutely. The foundational rules are built around ensuring transparency and honesty. One key aspect is the requirement that practitioners must furnish any information or records that the IRS requests if they possess them.
They can't just say no.
No, it isn't optional. It's a mandatory duty. I mean, imagine the chaos if tax professionals could simply refuse to provide information. It would severely impede tax administration. However, this isn't a blank check. There's a crucial exception. The practitioner may withhold information or records if they believe in good faith and on reasonable grounds to be privileged.
Like attorney-client privilege.
Exactly. That's the most common example. Legally protected confidential communications. It's a very specific and limited carve-out, not a general excuse to simply refuse a request. Furthermore, if the practitioner doesn't actually possess the IRS-requested information or records, but knows who does, they are under an obligation to inform the IRS of that person's identity.
Wow.
Yeah, this means they can't just claim ignorance or play dumb. They have a clear duty to direct the IRS to the correct source if they know it exists.
So essentially, your advisor can't just stonewall if they don't have the info. They're still obligated to point the IRS in the right direction, unless it's genuinely protected by legal privilege. It sounds like this rule is crucial for preventing any kind of deliberate obstruction of an IRS inquiry. Forces transparency.
Indeed, it's about ensuring a direct path to the facts. Moving on, what if they uncover a mistake or a potential misstep you've made? That's where the rules on knowledge of client omission, Section 10.21, come in. This is an incredibly active duty for the practitioner. If they know of a client's noncompliance with federal tax laws, or an error or omission on a tax return or any other document submitted to the IRS, they must advise the client of that specific noncompliance, error, or omission.
They can't just ignore it.
No, it's not enough to just notice it and remain silent. They have an affirmative responsibility to bring it to your attention. And crucially, it goes beyond merely pointing out the mistake. They also must advise the client of the consequences under the tax law that might arise from that noncompliance, error, or omission.
Okay, so they have to explain the potential penalties or interest.
Yes, exactly. This isn't just a passive observation, it's a proactive requirement to explain the potential fallout, whether it's penalties, interest, or maybe even more severe implications like criminal charges, depending on how serious it is. This ensures you, the client, are fully and properly informed before making any decisions about how to proceed. It's a powerful tool for your protection.
So it's not enough for them to just spot a mistake. They have to explain the potential fallout for you, the taxpayer. That's a huge safeguard, making sure you understand the risks involved and what needs to be done, like having a guide pointing out hidden potholes.
Exactly. And hand in hand with that is the requirement for diligence as to accuracy, Section 10.22. Practitioners must exercise due diligence, which basically means careful and thorough effort in two key areas. First, when they are preparing, approving, and filing tax returns and other documents that relate to IRS matters, this means checking their work, verifying facts, ensuring everything is correctly represented. They can't just, throw things together and hope for the best.
Right.
Second, they must exercise due diligence. in determining the correctness of any oral or written representations they make, whether those are made to their clients or directly to the Treasury Department. Every piece of advice or information they provide needs to be carefully considered for its accuracy. And an important provision within this diligence requirement is regarding reliance on others' work. In larger firms, or when collaborating, a practitioner is presumed to have exercised due diligence when they rely on the work product of another person,
Okay.
but only if they used reasonable care with respect to such reliance. This means a senior partner can't just blindly sign off on a junior associate's complex tax return. They still bear a responsibility to ensure the underlying work is sound, and that the person whose work they're relying on is competent, and that the work itself seems reasonable.
So the buck stops with the person signing.
Pretty much, yes. The buck ultimately stops with the signing practitioner.
This is about being meticulous, both in what they submit to the IRS and what they tell you. It underscores the importance of precision in every aspect of tax practice, almost a commitment to getting it right the first time.
It really is. And finally, a straightforward but vital rule under this transparency mandate is prompt disposition of pending matters, Section 10.23. It simply states, no practitioner may unreasonably delay any matter before the IRS.
Keep things moving.
Exactly. This emphasizes the importance of efficiency and timely action. This ultimately benefits you, the client, by avoiding unnecessary extensions, accumulating interest on unpaid taxes, or prolonged periods of uncertainty and stress while waiting for a resolution. The IRS expects practitioners to move cases along reasonably, not to drag them out to inflate fees or for other reasons.
Okay, so beyond just getting the facts straight, practitioners face strict ethical guidelines, especially when it comes to, well, tricky situations like past government service, how they handle fees, and even how they advertise their services. These rules seem designed to prevent conflicts of interest and ensure fair dealings, which is crucial for maintaining public trust, right?
Indeed. One area that often raises eyebrows is the revolving door between government service and private practice. Circular 230 has very strict rules regarding assistance from or to disbarred suspended persons and former IRS employees, Section 10.24. It explicitly prohibits practitioners from knowingly accepting help from or assisting any person who has been disbarred or suspended from practice before the IRS. This prevents individuals who have been disciplined from continuing to practice through others, essentially thwarting attempts to circumvent their sanctions.
Right, no backdoors.
Exactly. It also extends to accepting assistance from former government employees where specific conflict of interest rules covered in the next section, Section 10.25, or any other federal law, would be violated. The underlying principle is to maintain the integrity of the practice. This leads us directly to the more complex area of practice by former government employees, their partners, and their associates in Section 10.25. This raises an important question for taxpayers. How does Circular 230 prevent improper influence or conflicts of interest when someone who used to work for the government, perhaps even on your case, joins a private firm?
Yeah, that seems like a potential minefield.
It can be. The IRS wants to avoid that revolving door, creating an unfair advantage based on prior insider knowledge. The rules are quite detailed and depend heavily on the former employee's level of involvement. First, there's a firm isolation rule. A firm can represent a taxpayer even if a former government employee works there, provided the firm isolates that employee in such a way to ensure they cannot assist in the representation where a conflict of interest may exist.
How do they do that?
Yeah.
Like build a wall?
Sort of. It could involve physical separation, denying access to relevant files, clear policies preventing any discussion of particular matters. Think of it as a professional cone of silence around that individual within the firm for specific cases. Now let's break down the specific restrictions on the former employee themselves. These are crucial. If an individual, while a government employee, personally and substantially participated in a particular matter involving specific parties, say they were the lead agent on a specific audit of your company, or handled a specific tax court case involving you.
Okay, very direct involvement.
Very direct. That individual can never represent or assist those specific parties with respect to that particular matter. It's a lifetime ban on that specific issue. The once involved, always excluded rule for direct personal involvement.
Never. Okay.
Next, if an individual, while in government, merely had official responsibility for a particular matter involving specific parties, maybe they were a supervisor overseeing a unit that handled such cases but weren't directly involved in your specific audit.
Less direct, more oversight.
Right. That individual cannot represent those parties with respect to that particular matter within 2 years after leaving government employment. It's important to note here that the cannot assist language doesn't apply here. They just cannot represent the client themselves. It's a 2-year cooling off period for representation.
2 years. Got it.
Finally, there's a restriction related to influencing rules and regulations. Within 1 year after leaving government employment, the individual cannot appear before the IRS to influence any U.S. Treasury Department employee regarding any rule if either.
Mhm.
1, the individual at any time participated in the development of that rule, or 2, within the 1-year period prior to leaving government employment, the individual had official responsibility with respect to that rule. This aims to prevent former officials from immediately leveraging their knowledge of developing regulations for private gain, ensuring a fair legislative and regulatory process. Prevents an immediate jump from writing the rules to advising on how to get around them.
So this is designed to be very granular. If someone worked for the government on your specific case or helped shape a specific tax rule, there are very clear timeframes and restrictions on when and how they can then work in the private sector on related issues. It's all about preventing that revolving door from creating unfair advantages, ensuring government service isn't a direct pipeline to exploiting inside info. Sounds complex, but necessary.
It is complex, but yes,
Yeah.
very necessary. And on a simpler but equally important ethical note, Section 10.26 includes a strict rule regarding notaries. A practitioner may not act as a notary public for his or her clients on any tax matter.
Oh, interesting. Why is that?
It's a straightforward ethical safeguard. It prevents potential conflicts of interest or even the appearance of impropriety. Ensures the practitioner doesn't notarize documents they are involved in preparing or advising on, which could be seen as self-validation. It maintains an arm's-length separation between those roles.
Let's talk money. Section 10.27. That's always a big concern for clients. Does Circular 230 actually step into that delicate area, or is it mostly left to the market? I mean, can a tax professional pretty much charge whatever they want?
That's a great question. And yes, Circular 230 absolutely has rules about fees. The overarching principle is clear. A practitioner may not charge an unconscionable fee in connection with any matter before the IRS.
Unconscionable. What does that mean exactly?
Unconscionable here is a legal term meaning grossly excessive or unfairly disproportionate to the services rendered. It's a fee that, no reasonable person would agree to pay under the circumstances. It indicates a fundamental lack of fairness. What's particularly specific and often surprising in this section is the treatment of contingent fees. This is where the fee is a percentage of the amount recovered or based on whether a position taken on a tax return is successfully sustained.
Ah, the no-win, no-fee type arrangement.
Exactly. Circular 230 explicitly states that a contingent fee is allowable only in very specific and limited situations before the IRS. These are 1. During an IRS examination of or a challenge to an original tax return. This also includes an amended return or a claim for refund or credit that was filed within 120 days of receiving a written notice from the IRS of the examination or challenge to the original return. So if the IRS is actively scrutinizing the initial filing or a related claim, a contingent fee might be okay.
Okay, active challenge.
2, for a claim solely for a refund of interest and/or penalties. This is a very narrow exception, dealing only with the specific calculations of interest or the application of penalties, not the underlying tax itself.
Very specific.
And 3, in a judicial proceeding arising under the Internal Revenue Code. If the matter has escalated to court, then a contingent fee arrangement is permitted, as is common in litigation settings.
So those no-win, no-fee arrangements are highly restricted, primarily reserved for situations where the IRS is actively challenging a return, or when the matter goes to court, or for very specific penalty or interest claims. This prevents practitioners from taking on overly speculative cases on a contingent basis outside these narrow scenarios, protecting clients from practices that might encourage reckless advice. Seems sensible.
It is. Another critical protection for clients, Section 10.28, and one that's often overlooked, is the rule dictating the return of clients' records. The general principle is crystal clear. A practitioner must, at the client's request, promptly return any and all client records that are necessary for the client to comply with his or her federal tax obligations.
So they can't hold your stuff hostage.
Exactly. It ensures that clients aren't held hostage by their own documents if they choose to move to another practitioner or handle matters themselves. The practitioner is, however, allowed to retain copies of the records they return. Now, there's an important nuance here regarding fee disputes. If state law allows a practitioner to retain records in the case of a fee dispute, which some state bar or accounting rules do permit, often called a retaining lien, they may do so.
Ah, okay. So sometimes they can keep them.
They can potentially retain them, yes, but even then, Circular 230 imposes a further crucial requirement. They must provide the client with reasonable access to review and copy any retained client records that are necessary for the client's federal tax obligations. This means they can't simply deny you access to your vital documents, even if a payment dispute exists. And client records are broadly defined, includes materials you gave them and stuff they prepared for you, like returns or refund claims. It's a comprehensive definition designed to protect your access to your own information.
That's a significant protection. Your records are your records, even if there's a disagreement over payment. They can't hold your essential documents hostage, ensuring you can still meet your tax obligations. Dramatically reduces opportunities for undue leverage. Gives you peace of mind.
Absolutely. Then we have the broad but vital area of conflict of interest in Section 10.29. The general prohibition is straightforward. A practitioner may not represent a client before the IRS if it involves a conflict of interest, designed to ensure undivided loyalty.
Makes sense, but are there exceptions? Sometimes conflicts seem unavoidable, maybe representing spouses or business partners.
There are, but it's a very narrow path with 3 specific conditions that must all be met for a practitioner to represent clients despite a conflict. 1, the practitioner reasonably believes that they can competently represent each of the clients. This is an objective standard. They can't just think they can. It must be objectively reasonable, even if the client's interests diverge somewhat.
Okay, reasonable belief.
2, no state or federal law prohibits such representation. Even if Circular 230 allows it under these conditions, other laws might forbid it.
Right, other rules might apply.
And 3, this is the big one. Each affected client waives the conflict of interest, gives informed consent, A&D confirms the waiver in writing within 30 days after giving informed consent.
Informed consent and in writing.
Yes, and multifaceted. Informed consent means the practitioner has fully explained the nature of the conflict, the potential risks, the possible advantages and disadvantages. The written confirmation ensures a clear, documented record, preventing later disputes about whether the client truly understood.
So while conflicts are generally forbidden, there's a very narrow path if transparency, truly informed consent, and competent representation can all be guaranteed for everyone involved. That's a really high bar. It really raises the question, how does a practitioner ensure informed consent when dealing with complex conflicts, especially with maybe less sophisticated clients? What are some challenges there?
It is a high bar and a huge challenge. A common pitfall is assuming the client understands the nuances just because it's been stated. Practitioners often need to use really clear, simple language, maybe even provide examples to make sure the client truly grasps the implications. Another challenge is when the conflict isn't obvious up front, maybe only emerging later. That's why the reasonably believes standard forces ongoing reevaluation. It's really about building trust through transparency, not just, checking a box.
That makes a lot of sense. Okay, so moving from how they handle existing clients to how they get new ones. Section 10.3, solicitation. What about advertising? Say you just say anything to get business?
No, definitely not. Section 10.3 has very clear guidelines designed to prevent misleading practices and ensure honesty in marketing. Under the advertising and solicitation restrictions, a practitioner cannot use or participate in any public communication or private solicitation that contains a false, fraudulent, or coercive statement or claim, or a misleading or deceptive statement or claim.
Pretty broad prohibition.
It is. It's aimed directly at ensuring honesty and truthfulness. For example, the source material gives a specific illustration. Imagine an accounting firm, just CPAs, advertising on TV saying, "Our talented staff of licensed attorneys and CPAs guarantee you the tax refund you've always wanted."
Okay, I see problems there.
Right. 2 likely violations. First, falsely advertising licensed attorneys when they don't have any. That's a false claim. Second, including a guarantee about a tax refund is highly problematic. Refunds depend on individual facts and law, not a preparer's guarantee. Such a promise is misleading, implies a certainty that just isn't real.
Sets unrealistic expectations.
Exactly. Furthermore, if practitioners publish a written schedule of fees, they must honor those fees for 30 days following the last date they were published. This provides price transparency and stability, preventing bait and switch. And if additional fees might be charged for certain things like maybe audit representation isn't included in the basic prep fee, the statement must clearly indicate whether clients will be responsible for those extra costs. No hidden surprises.
Good. Transparency on fees is key.
And there are also very specific record-keeping requirements for communicating fee information. For radio and TV ads, the broadcast must be recorded, and the practitioner must keep a recording of the actual transmission. For direct mail and e-commerce, they must keep a copy of the actual communication, plus a list or description of recipients. All these copies and records must be retained for at least 36 months from the date of the last transmission or use. Ensures a clear audit trail for the IRS if questions about advertising practices come up.
That's quite detailed for advertising. It's all about ensuring transparency and honesty in marketing, especially when it comes to promises about tax outcomes or staff qualifications, clearly designed to protect you from being misled.
Indeed. And on a very practical note, Section 10.31, negotiation of taxpayer checks, is a very clear and strict rule. A practitioner may not endorse or otherwise negotiate any refund check issued to a client.
So they can't cash your refund check for you.
Nope. It's a key safeguard against potential fraud, commingling of funds, or any appearance of impropriety. Your refund check should go directly to you, the taxpayer, not through your preparer's bank account. It's a bright-line rule to prevent abuse.
That is a key safeguard. Ensuring your refund goes directly to you dramatically reduces opportunities for misconduct. Very sensible.
Finally, within this set of duties and restrictions, there's an important clarification about professional boundaries in Section 10.32, Practice of Law. Circular 230 explicitly states that it may not be construed as authorizing persons, not members of the bar, to practice law. Meaning that while a CPA or an enrolled agent can certainly give you tax advice and represent you before the IRS, these regulations do not grant them the authority to do things that constitute the practice of law, like drafting wills, setting up complex legal trusts unrelated to tax planning, or representing clients in non-tax legal disputes. It's a recognition of distinct professional scopes and prevents non-lawyers from straying into areas where they lack the specific legal training and licensure required.
So, while a CPA might give you excellent tax advice, this doesn't automatically make them your lawyer, and they must operate strictly within their professional scope. Respecting boundaries. Got it. Now, Circular 230 isn't just about what not to do, right? It also sets out best practices for truly high-quality tax advising. It sort of moves beyond mere compliance to fostering excellence, almost like a roadmap for the ideal advisor.
Exactly. Section 10.33 actually outlines these best practices for tax advisors, which are designed to ensure clients receive the highest quality representation. There are 5 key areas that really elevate the standard. 1. Communicating with the client regarding the terms of the engagement to determine the client's purpose and intended use for the advice. Ensures clarity from the start. Make sure advice is tailored.
Good communication up front.
2. Establishing the facts and arriving at a conclusion supported by the law and the facts. This means thorough factual investigation and legal research. Building a robust argument based on reality, not wishful thinking.
Solid foundation.
3. Advising the client about the importance of the conclusions reached. For example, whether the client will be able to avoid penalties. Practical, actionable advice considering real-world implications, especially risks and penalty avoidance.
Practical consequence.
4. Acting fairly and with integrity in practice before the IRS. A broad ethical mandate, reinforcing honest, principled conduct in all interactions with tax authorities.
Fairness and integrity.
And 5. Taking reasonable steps to ensure that all members, associates, and employees of the firm follow procedures that are consistent with the above. This extends responsibility beyond the individual to the entire firm, ensuring a culture of compliance and high standards.
That's aspirational. Not just compliance, but true excellence. But in practice, how challenging is it for firms, especially maybe smaller ones, to genuinely embed this culture and ensure all their employees are consistently meeting these best practices? Especially when deadlines loom or clients are demanding, sounds like a constant uphill battle.
It absolutely can be, and that's a very insightful point. For smaller firms, resources might be stretched, making it harder to implement robust internal training and review processes like larger firms might have. However, Circular 230 frames these as reasonable steps, acknowledging that what's reasonable for a solo practitioner might differ from a global accounting giant. The key is the effort to foster that culture. It's a continuous commitment, not a one-time fix.
Okay, reasonable steps.
And tying into that, Section 10.35 addresses competence. The core requirement is unequivocal. A practitioner must possess the necessary competence to engage in practice before the IRS. It's not a suggestion, it's fundamental.
Like the doctor example, you need the skills.
Exactly. You wouldn't want a doctor operating without the right skills, and the same absolute standard applies to your tax advisor. Competent practice is defined as requiring the appropriate level of knowledge, skill, thoroughness, and preparation necessary for the matter for which the practitioner is engaged. This means they must have the specific expertise needed for your particular tax situation, not just general knowledge.
And if they don't?
Well, it clarifies how competence can be achieved. It's not an excuse to be ignorant. A practitioner can become competent through various methods, such as consulting with experts in the relevant area or studying the relevant law. If they don't know something, they have a duty to learn it, research it, or seek advice from someone who does. This ensures you're always getting advice from a qualified source.
So it's about ensuring they are genuinely qualified for your specific needs. And if they're not, they have an obligation to either get qualified or refer you. That's a crucial level of assurance. Okay, let's move into section 10.34 and 10.37. This is what really impacts most of us. The rules for preparing and submitting tax returns and other documents, and the standards for written advice. This is where the rubber meets the road for the vast majority of taxpayers, right?
Indeed. Section 10.34 covers standards with respect to tax returns and documents. The rules are very strict, aiming to prevent anything misleading or fraudulent. A practitioner may not willfully or recklessly sign a tax return or advise a client to take a tax position that, 1, lacks a reasonable basis. There needs to be a credible legal and factual argument, not just a guess.
Reasonable basis.
2 is an unreasonable position. This is beyond just lacking a reasonable basis. It implies the position is so unlikely to be upheld that it's just inappropriate, risking penalties for you.
Unreasonable. Got it.
3 is a willful attempt to understate tax liability. This targets deliberate efforts to cheat, basically.
Intentional understatement.
And 4, recklessly or intentionally disregards the tax rules and regulations. This covers acting with extreme carelessness or deliberately ignoring known tax law.
Think of it this way. This rule isn't just about catching bad apples. It's Circular 230's proactive shield for your financial future. It means your tax advisor must be your frontline defender against overly aggressive tax schemes, forcing them to prioritize legal soundness over risky gambles, knowing you're the one who ultimately pays the price. That's a huge safeguard.
Absolutely. And similarly, when it comes to documents, affidavits, and other papers submitted to the IRS, practitioners cannot advise a client to take a frivolous position. A frivolous position is one that is baseless, clearly lacks legal merit, or is intended simply to delay, like advising a tax protester argument that courts have shot down repeatedly.
No frivolous arguments.
Right. Beyond that, they also cannot advise submitting any document that 1, will delay or impede the administration of federal tax law, no stalling tactics. 2, is frivolous, reinforcing that point. Or 3, contains or omits information demonstrating an intentional disregard of a rule or regulation, unless the practitioner also advises the client to submit a document evidencing a good faith challenge to the rule or regulation.
Ah, the challenge exception again.
Yes, it's a critical nuance. If a practitioner genuinely believes a rule is wrong and should be challenged legally, they can advise taking a contrary position. But they must clearly document that challenge for the IRS, showing it's a legitimate legal dispute, not hiding noncompliance, transparency, and disagreement.
So no intentional delays, no baseless arguments, and if they're challenging a rule, they need to document that clearly and transparently, have a legitimate reason, and make it known.
Exactly. And a truly critical duty for your protection is advising clients on potential penalties within this section. The practitioner must inform the client of any penalties reasonably likely to apply to a position taken on a return or document, especially if they advised on it or prepared it.
They have to warn you.
Yes, ensures you understand the financial and legal risks. And importantly, they also must inform the client of the opportunity to avoid penalties if the client discloses the position taken and the requirements for adequate disclosure. This is proactive guidance, incredibly valuable. Not just warning about penalties, but explaining how to avoid them through proper, transparent disclosure. Empowers you to make informed decisions and mitigate risks. They are your navigators through potential minefields.
They're not just your tax preparer, they're your guide to potential risks and the clear path to avoiding them through proper disclosure. Huge value add, ensures you're not left in the dark.
Moving to how practitioners handle the information you give them, still in Section 10.34, it clarifies the practitioner's reliance on information furnished by client. Generally, a practitioner signing a return may rely in good faith without verification upon information you provide.
They don't have to audit my shoebox.
Pretty much no. They can generally trust your input. But UT, and this is a big but, they cannot ignore the implications of that information or any contradictory information they already know. Moreover, they must make reasonable inquiries if the information furnished by the client appears questionable or incomplete. Example: you report modest income, but suddenly provide receipts for a huge business expense. They can't just accept it blindly. They must ask follow-up questions.
Okay, gotta use common sense.
Exactly. It strikes a careful balance. Trust the client, but exercise professional skepticism. acts as another layer of quality control.
Right, that strikes a careful balance. They can trust you, but they can't be willfully blind if something seems off. Places a responsibility on them to question things. Okay, now, Section 10.37, Standards for Written Tax Advice. Many of us rely on written advice, emails, memos, reports. Are there specific rules for how that advice is given? Seems like it should be held to a particularly high standard.
You're absolutely right. It is held to a high standard. Circular 230 sets stringent rules here. This covers pretty much any written advice, including electronic, concerning federal tax matters, anything related to the tax code, your obligations, or IRS-administered law. The practitioner providing this advice has several key requirements. 1. It must be based on reasonable factual and legal assumptions, including about future events. No wild guesses.
Reasonable assumptions.
2. They must reasonably consider all relevant facts and circumstances known or reasonably knowable. No cherry-picking facts. Holistic view needed.
All relevant facts?
3. They must use reasonable efforts to identify and ascertain the facts relevant to the advice, expected to dig deeper if needed.
Do their homework on the facts?
4. They must not rely unreasonably upon representations, statements, findings, or agreements from you or others. If something looks too good to be true or comes from an unreliable source, they need professional skepticism.
Don't rely unreasonably.
5. They must relate applicable law and authorities to facts. The advice needs to show a clear link between legal principles and your specific situation. Tailored, not abstract.
Apply law to facts.
And 6. Critically, they must not, in evaluating a federal tax matter, take into account the possibility that a tax return will not be audited or that a matter will not be raised on audit.
Ah, the audit lottery rule.
Exactly. This is huge. Their advice must be sound on its own merits, as if it will be scrutinized by the IRS, rather than relying on the slim hope that no one will ever look at it.
That seemingly small clause that advisors cannot factor in the chance of an audit is actually the ethical backbone of all tax advice. It means every recommendation has to be ironclad, built to withstand scrutiny, not relying on hope. That, for a taxpayer, is the ultimate assurance of integrity.
Yeah.
Forces meticulousness.
It truly is. Building on that, when a practitioner relies on someone else's expertise, Section 10.37 also covers reliance on advice of others. A practitioner may rely on another person's advice if the advice was reasonable and the reliance is in good faith, considering all facts. Acknowledges consulting specialists. However, this reliance is not considered reasonable when 1. The practitioner knows or reasonably should know the other person's opinion shouldn't be relied on. For example, it seems flawed or contradicts known law.
Okay.
2. The practitioner knows or reasonably should know the other person is incompetent or lacks the necessary qualifications. Can't get advice from someone unqualified and claim reliance. Got to vet consultants.
Right.
And 3. The practitioner knows or reasonably should know the other person has a conflict of interest violating Circular 230. Prevents getting tainted advice from someone with ulterior motives. Ensures impartiality.
This means they can consult others, but they can't just blindly pass the buck. They still have to use their own judgment about the quality and impartiality of that advice. The ultimate responsibility rests with them.
Exactly. And to ensure these standards are met, Circular 230 includes a standard of review for written advice. When evaluating compliance, the IRS applies a reasonable practitioner standard. They'll consider all facts and circumstances, including the scope of the engagement and the type of advice sought. It's pragmatic. What would a reasonably competent and ethical practitioner have done? There's an added layer for sensitive situations. If the advice is known or likely to be used for promoting tax avoidance or evasion schemes, the reasonable practitioner standard is still applied, but with careful, heightened consideration of all facts to prevent abuse. The IRS is very alert to advice crossing into promoting illegal activities.
Okay, and it's not just about individual practitioners, right? Section 10.36 suggests the entire firm has obligations, extends responsibility to leadership.
Precisely. Circular 230 in Section 10.36 places responsibility directly at the top. Individuals who have principal authority for overseeing a firm's federal tax practice must take reasonable steps to ensure the firm has adequate procedures for Circular 230 compliance.
So firm leaders are on the hook.
Yes. They aren't just responsible for their own conduct, but for putting systems in place like training, review processes, quality control that guide all their employees to adhere to these regulations. This section also details when those in authority can be held responsible for compliance failures by others in the firm. 3 main scenarios. 1, if the individual fails to have adequate procedures, there's a pattern or practice of noncompliance, and this happens through their willfulness, recklessness, or gross incompetence. holds them accountable for systemic failures.
Okay, failure to set up procedures.
2, if the individual fails to ensure the procedures are followed, leading to a pattern of noncompliance, also through willfulness, recklessness, or gross incompetence. Procedures might exist on paper, but leaders aren't enforcing them.
Failure to enforce.
And 3, if the individual knows or should know of a pattern of noncompliance and fails to take prompt action to correct it. A direct duty to intervene when aware of issues can't turn a blind eye.
Failure to act when they know. So it's not just individual bad actors. Firm leaders can be accountable if they don't create and enforce a compliance culture. Connects to trust in the whole industry. It's an overarching responsibility.
Okay, we've covered a lot of rules, duties, best practices. Let's get to subpart C. What happens if a practitioner, despite all this, falls short? What are the consequences for violating Circular 230?
The consequences can be quite severe, definitely impacting a practitioner's career. The Secretary of the Treasury, after due notice and opportunity for a proceeding, meaning they get a fair chance to defend themselves, has the power to publicly reprimand, suspend, or even disbar any practitioner from practice before the IRS.
Reprimand, suspend, or disbar. Serious stuff.
Very serious. The core reasons for sanctions are broadly defined. Being shown to be incompetent or disreputable, failing to comply with any Circular 230 regulation, or willfully and knowingly misleading or threatening a client or prospective client with intent to defraud. These broad categories cover a wide range of misconduct. This really highlights the seriousness. It's not just a slap on the wrist. They can lose their ability to practice before the IRS entirely, which for many means losing their livelihood, a very real threat.
It is. And to give a clearer picture, Circular 230 provides an extensive list defining what constitutes incompetence and disreputable conduct warranting sanctions. This list really underscores the comprehensive nature of expectations. Let's hit some key examples. Criminal convictions. Being convicted of any federal tax crime or any crime involving dishonesty, breach of trust, or any felony showing unfitness to practice covers actions impacting professional integrity.
Okay, criminal behavior.
Dishonesty and misrepresentation. Giving false or misleading info to Treasury or tribunals. Using threats or bribes to influence IRS employees. Core honesty issues.
Lying or bribing.
Tax evasion or noncompliance. This is a big one. Willfully failing to file their own tax return or willfully evading their own taxes. Also, counseling or helping others evade taxes shows fundamental disrespect for the law they advise on.
Can't evade their own taxes.
Wow. Misuse of client funds. Failing to timely send the IRS client funds meant for tax payments prevents embezzlement.
Handling client money improperly.
Violating advertising and disclosure rules includes the false advertising examples we discussed. Also, willfully disclosing taxpayer info without authorization protects privacy.
Bad advertising or privacy breaches.
Professional malpractice and bad faith. Knowingly, recklessly, or through gross incompetence, giving false tax opinions. Willfully failing to sign a return when required as a paid preparer, unless there's reasonable cause. Accountability for advice and documents.
Giving bad advice or failing to sign. That's a long list. This comprehensive list really underscores that Circular 230 covers not just direct tax advice, but a broad spectrum of professional and ethical conduct. Highlights the immense responsibility, paints a clear picture of what can lead to losing the privilege to practice. So if a practitioner is sanctioned, say, disbarred or suspended, is that it? Lifetime ban. Or is there a path back? Subpart D, Section 10.81, talks about reinstatement.
It's not always permanent, which offers a possibility for rehabilitation. Circular 230 outlines a petition for reinstatement. A practitioner who has been disbarred or suspended may petition for reinstatement before the IRS.
Okay, they can ask to come back. When?
There's specific timing. They could petition after the expiration of 5 years following such disbarment or suspension. Or if the suspension was shorter than 5 years, they could petition immediately after the suspension period ends. So a minimum 5-year wait for disbarment or long suspensions.
5 years is a long time.
It is. And the conditions for reinstatement are strict. It will not be granted unless the IRS is satisfied that the petitioner is not likely to engage thereafter in conduct contrary to the regulations in Circular 230, and that granting reinstatement would not be contrary to the public interest. It's a very high bar. Requires genuine rehabilitation, proof they pose no future risk to the public or the tax system's integrity.
So there's a long road back, but it's only granted if the IRS is truly convinced they've turned over a new leaf and won't pose a risk. Speaks to the seriousness of maintaining integrity, but also allows for genuine reform.
Wow, what an incredibly comprehensive deep dive into Circular 230. We've really uncovered the detailed rules ensuring integrity, diligence, and competence for those practicing before the IRS. It's far more detailed and protective than I ever imagined.
Indeed. Circular 230 truly is the unseen bedrock of trust in our tax system. It ensures the professionals you rely on are not only knowledgeable about complex tax law, but also uphold the highest ethical standards in their dealings with you and the IRS. It protects your interests and the integrity of the tax administration as a whole. It's a continuous, dynamic commitment to professionalism that often goes unnoticed. And knowing these rules empowers you as a taxpayer. You now have a much clearer understanding of the ethical framework your tax advisor operates within, what constitutes best practice, and the consequences for falling short. It's your shortcut to being well informed about the rules of the road for tax professionals, helping you choose and trust your advisors more confidently, and maybe even know when to ask important questions.
Absolutely. This deep dive shows the immense trust placed in tax practitioners, but also the rigorous system upholding that trust, which, raises an important question as we look ahead. In an increasingly complex global economy, and with all these evolving digital financial tools, think AI for tax prep, the complexities of crypto, how might these foundational regulations need to adapt in the future to keep pace?
Good question.
Ensuring client protection and professional accountability will remain paramount, of course. But how do we balance that with embracing new technologies and the ever-changing challenges in the tax landscape?
That is a fascinating thought to mull over as you consider your own financial landscape and the future of tax advice. Thank you so much for joining us on this deep dive. We hope it's given you valuable insights and maybe a newfound appreciation for the incredibly detailed world of tax practice.